that the law doesn't sort of tie our hands so rigidly that we can't do our business, and also that the public feels like they're getting a chance to speak, you know?
Right. No, I agree.
Continuance.
And a good presiding officer will watch what's going on and make sure that people are feeling like they've had the opportunity, and at the same time not provide so much time that people are repetitive,
Right.
the deliberating body or the public is getting tired and affecting the ability to make good decisions based
Right.
on information. So
Right, and some bodies use the comment cards that are filled out prior for the purpose of sort of, you know, organizing and administrating, okay, we've got 16 people here that are in favor of Proposition X or whatever it is. We've got two, you know what I mean? So you sort of try and make sure
Right.
that the meeting is run as smoothly as possible while respecting the public's right to speak and hear.
Actually, it's not bad for people in the chair when people make the comment about they're going to speak to item 6.1 and they come to the podium and they're not speaking to item 6.1. The chair does have the ability to shut that conversation down. Now, people may not like that, but the fact is if said they were going to speak to a specific item and they were nowhere near it.
Right, and you say, please, when we call 6.1, please come up then to speak.
Yeah.
Or if they're talking about an item that's not on the agenda, encourage them to come to that portion of the meeting to speak, right?
Yeah.
That it's always a tricky situation because you want to.
It's a fine line.
It's a fine line. You want to be sure that the public feels respected and accommodated, but you also want to make sure that the public's not abusing you or your staff, right? If you're at a regular meeting and it goes until midnight, you decide, okay, let's continue this until day after tomorrow. The law says that because it's less than 5 days away, you don't have to post a new notice. That adjourned meeting can take place a day and a half later without a new notice being posted. You do have to post a notice of adjournment on the door within 24 hours after the adjournment. I don't know if that happens a lot here where you end up having to adjourn.
One time when we had a 2-day meeting.
Right. And the idea is somebody can say, oh, they didn't finish, let me come back tomorrow. If you're continuing until the next morning and it's less than 24 hours, you have to post immediately, which is sort of makes sense. Gender requirement does not apply when certain unnoticed topics are discussed at a notice meeting. So what are we talking about here? We are talking about these 3 exceptions to the rule that it must be on an unnoticed agenda. So emergencies are pretty clear, right? I think we're talking about crippling activity, work stoppage, other activities severely impairing public health. Let's talk about matters that require immediate action that cannot wait. So I see the clerk smiling because this is the bane of the clerks and the city attorneys and the general counsel's existence sometimes. For a regular meeting, your agenda has to be posted 3 days before, 72 hours before, and then it sometimes happens where somebody on the staff or somebody from the public says, I really need this item to be decided. Can we add it to the agenda? Have you gone through this process at your board meetings?
That's happened before where we'd really like to get it on, but that does not qualify.
Right, and the secretary has made a good point. It doesn't qualify under the statute. So there are very specific rules about when you can add an item to the agenda. And they are, let's see if I have them. No, but I know them. The rule is that you can add an item to the agenda upon a vote of 2/3 of the full majority of you, if you're all here, or if less than a majority, if less than 2/3 are here, then a unanimous vote of whoever is there, making the following findings. 1, that there is a need to act on this item before your next regular meeting. 2, that the need came to the agency's notice, not to the board's notice, but to the agency's notice after the posting of the agenda. And 3, that you have to act, right? And it requires an affirmative vote by the board.
in public.
In public. You can't go into closed session on these items. I love that. I'm not sure what it looks like on your screen, but that's a skyline of lights out,
Okay.
a blackout in New York, I guess. You've got to give the media notice that you are having or calling an emergency meeting, unless your phones don't work. And you've got to give that notice as soon as you give it to the members of the board that you're having an emergency meeting. Minutes must be posted for 10 days in a public place after that meeting is adjourned, which means the clerk has to get on those minutes right away. Here we go. Here's the.
And that's another
the
reason
statute.
for
Sorry
action
about that.
minutes.
We talked about this already, right? Your accessible notice, your agenda, an accessible place.
Yeah, and I'll tell you an anecdotal bit of information about posting. A while ago, I was attending meetings in absentia by telephone out of state, in fact, halfway across the country, and we were required to post notices. And the joke was, how many people do you think are going to show up at this meeting in Texas? Right?
And we'll go through. We will go through the rules for what Trustee Otto just described as a teleconference meeting. The Brown Act allows for us to teleconference in meetings. And I think we're almost there, quite frankly.
We would actually we would actually take pictures of me
Oh, yeah.
with my arm around the notice so that we knew that.
I believe that, and I would actually recommend that, right? Because the rules actually very very picky and strict. I mean, you run the risk of being accused of a Brown Act violation for not having posted the agenda properly at your teleconference location. The Brown Act requires that if a member of the public requests agenda materials in an alternative format, Braille or other disability-friendly manner, that we do so, and they have to request it within a reasonable time, and you can't give them unreasonable deadlines. So, for example, you can't say you must request this assistance within 72 hours of the regular meeting, because no later than 72 hours of the regular meeting, because guess what? The agenda didn't get posted until 72 hours before the regular meeting, and it's on your agenda. Good. And what is your deadline? 24 hours before the meeting?
Actually, it just says to contact us, so we'll.
At any time? Okay, good. We just had this conversation about time limits on public input, as well as procedures. And it sounds like you have well-defined procedures, which is great. This notion here of limiting the topics of what can be discussed by members of the public, in some communities it's a big deal, and in others it's not, and I don't know what it's like here, but what the law requires is that you've got to give members of the public the opportunity to speak about anything within your subject matter jurisdiction. So that's, it's both narrow and broad, right? You're not the Long Beach City Council, so they're not going to come talk to you about the Long Beach cops, I hope.
We actually, we have a contract with the Long Beach Police Department to patrol here,
I
so.
apologize. I wish I could think of a better explanation. They're not going to come talk to you about the city attorney in Long Beach.
Yeah.
Charlie Parkin, that guy. But so you understand the concept, right? And there's some agencies that will sort of let people talk about anything and everything that's of a public interest. I find that challenging, quite frankly, because sometimes you'll get members of the public who want to come and talk about, the war in Afghanistan or what have you. And it's a balancing this thing, right? Every public meeting is not an open forum. That's really what it comes down to. For the lawyers in the room, that's First Amendment law for us. Oh, here we go. I think we beat this horse already. Any questions on this?
I actually have a question.
Sure.
So what if it's related to, like, hypothetically, a closed session item?
Uh-huh.
How is that dealt with?
The public doesn't have a right to see closed session materials.
Right. So if it's, does the communication have to happen in the closed session, or can we have communication priorhand to before the closed
So
session?
you're talking about confidential memos to the board on the topic of the closed session from your attorney or from the staff?
Yeah, it could be from like a board member to board member. It may not necessarily be marked confidential, but it's pertaining to the closed session agenda item.
Okay, so let's separate them out a little bit, because there's going to be a different conversation. If it's pertaining to an agenda item, for a closed session agenda item that comes from your staff, the only rule, and quite frankly, it's not even a rule. This is just a best practice as an agency lawyer. If I'm sending a memo to one board member, informing them or answering a question about a closed session item, I send it to the rest of the board so they all have this benefit of the same information. And I'm assuming your staff does the same thing. A closed session memo or closed session materials are sent to the full board.
Yeah.
They can be sent before the meeting. They don't have to be sent before the meeting. There are some agencies that will say, for a variety of reasons, our best practice is going to be that we're only going to distribute written material about the closed session at the closed session, so as to protect our confidentiality. And the additional step that usually happens in that circumstance is whatever material has been distributed to the board and any staff present is then collected at the end of the closed session to make sure that it's all controlled and there's not a chance that somehow it can get leaked out in violation of the Brown Act. So that's that issue. The other issue you talked about, though, was a communication between or among board members about a closed session item.
Yeah, before the closed session item.
So that's a tricky situation because it could be viewed as either a Brown Act violation itself or a potential Brown Act violation. Because if a board member is communicating with more than a majority of the board about an agenda item outside of the closed session, it's technically outside of the rules because you're trying to develop a collective concurrence, arguably, right? So there's the statute is not 100% clear. So there are, for example, there's a case that says one-way communications to a majority of the board are allowed. I think the case is a City of Palmdale case, and it deals with a memo from the city attorney on a closed session item. And someone brought an action saying, hey, that's against the law. The board shouldn't be able to get that, and it should be public information. And the court said, no, the board is entitled to receive information from their attorney on a one-way communication. And it's not a public document, and it's not a Brown Act violation because the one-way memo is not resulting in a conversation or a sharing of information among the board members, right?
Right, but that was from the attorney. What if it was a fellow?
So my point is it's equally dangerous for a board member to say to the rest of the board, I feel X way about closed session item B. What do you think? Now, the what do you think part, maybe it's not there, but I feel X way. It's not necessarily a Brown Act violation by itself, but it could be viewed as a potential Brown Act violation, and it could certainly lead to a Brown Act violation by people responding to it, for example. Or let's just say that I'm a member of my local school board, and I send a memo to 4 of my colleagues, sort of going through all my rationale as to why I'm going to make a vote before the meeting. And they all get it. None of them reply to it, respond if it's an email, or they don't send memos back. But 2 of them get together, as they're entitled to do, to talk about an item. And they happen to say, did you see Ruben's memo? That guy's full of crap. Then all of a sudden, you've got the second and third board members who are part of that conversation, along with my point of view in their conversation, creating a majority of the board members sort of speaking. That's a serial meeting, quite frankly.
So it's irregardless of whether it's an open session item or a
irrespective, closed session items. Because what the law where it's getting to is the consideration of the closed session item should only happen in the closed session itself, so that all the board and the staff who are entitled to be there are privileged to the same information.
How do you correct that if it hypothetically happens? Do you have to disclose that communication, that written communication, publicly to cure and correct?
It's a very good question. So what the Brown Act provides in terms of correcting violations is, and there's a whole, we'll get to the slides in a little bit later, but essentially it's this process of notice and cure. Okay, so if someone learns that a Brown Act violation happened, they have a right to tell the public agency, look, you're in violation of the Brown Act, we demand that you cure. For an open session item, it's sort of easy, because then what you do is you agendize the item again, and you have the discussion and the full view and hearing of the public, because what you've deprived them of was the benefit of your discussion in public. For a closed session item, I'm not sure that there's an effective cure. However, if a decision was made as a result of that illegal Brown Act violation, then the decision itself is subject to being overturned by a court. Certainly, the decision is subject to being criticized and derided in public. The cure for that is to have a new closed session and just put it all on the table again in the proper way, I think. I mean, it sort of depends on each individual situation. You have to look at how the violation happened and what was the harm to the public. Okay. We talked about this. We talked about this. Here's a note for you, Ms. Hahn. Include on the agenda a note that agenda materials are available for public inspection at the Secretary Clerk's office. You probably have that if you don't already. Okay. The Brown Act lays out specific requirements for what the agenda must list and what must say for closed session items. You must give the public notice of what's going to be discussed in closed session. Prior to adjourning into your closed session, somebody from either your body or your staff must make an announcement of what's going to be discussed at closed session. Now, what the law says is you can simply refer to the agenda and say, we're about to adjourn into recess into closed session. We're going to discuss items 1 through 3 as listed on the closed session agenda. But that verbal announcement must be made. I think as Ms. Hahn pointed out, the public has a right to speak on closed session items before you actually convene into closed session, so that so you can hear what their thoughts and their concerns are. And at the conclusion of the closed session, the law requires that you come back out into open session, reconvene as a body, at least a majority of you, and let the public know that you met in closed session. And if there are decisions that were made that are required to be reported by the Brown Act, you make that report at that point.
Is the language of the statute that is quoted, that allows you to discuss that subject in open session, adequate notice, or must you be specific about what the litigation is?
It depends on the type of closed session item it is. So for certain litigation items, there are more specific requirements that must be complied with depending on the status of the litigation, essentially. And we'll get through those specific rules in a little bit. We just talked about this. This is essentially the safe harbor rules. I'm sure you follow the safe harbor rules when you're describing your closed session items, which is good. Which essentially says you can't be sued or found liable for a closed session that was. If you comply with the safe harbor, then you can't be sued for having a closed session that was outside of what the notice was about. So, for example, the litigation or the personnel item.
Can you explain the safe harbor concept a little bit?
Sure. So the legislature has said to governmental bodies, okay, look, we know you need to meet in closed session. We're going to very, very closely limit what you can meet in closed session about to these 4 or 5 topics. Right. On top of that, we're going to give you some magic language so that you don't have to worry about how to properly characterize the item on your closed session. That one, it gives the public sufficient notice of what you're going to be talking about, but 2, it gives you not the satisfaction, but the certainty of knowing that whatever you use to describe it is going to be safe, that it's going to be beyond reproach, and that you don't have to worry too much about properly characterizing it. At what stage of the litigation are we, for example, right? You don't have to get into that sort of detail. You just have to tell the public we're going to talk about, if it's a case that's ongoing, Ruben Duran versus the city of Berkeley, and the case number. Mm-hmm. That make sense?
Sure.
Okay.
Can I ask you, and only because you said the comment, you said when we're going to adjourn to our closed session, and we've talked about this. When you adjourn, then you close the meeting down. You take a vote, and I have always said we're going to recess to a closed session. I don't know if you just used the term.
I did use it loosely, and I don't know if you noticed, but I later said convene or reconvene.
I picked up on how you reconvene, which means, well, how do you reconvene when you adjourned? And I know I'm into wordsmithing here, but I will traditionally, because actually our board secretary has said you should be adjourning, and I said, well, we're really recessing, but as long as I don't end up in jail, I guess we're okay.
I think it's one of those Robert's Rules sort of things that came about. I mean, a lot of us like to think we know and we follow Robert's Rules, and we should because of parliamentary procedure, and that's just how it's done. However, the Brown Act and Robert's Rules don't always jibe very well, and so it could be a vestige of that, quite frankly, or we could just be mistaken. or she
Yeah.
could be mistaken.
Yeah,
I mean,
and Robert's
Not
rules was
Jackie,
made for very
not Jackie.
large bodies. I
yeah.
mean, that was the
But you're
original
right,
intent
when
of
you're
Robert's
adjourning a
rules.
meeting, you're essentially saying, hey, we're stopping this meeting and we're gonna go meet somewhere else at another time.
Yeah.
Well, what you're adjourning is the open session portion to go convene into the closed session portion, right? But that's a little cumbersome to say. And I think that's why people say, well, we're adjourning into the closed session. Really what you're doing is you're taking the open session part of the meeting and you're moving it to you're convening the closed session. And then you're gonna come out of the closed session to reconvene the open session. Right? Yeah, I get it.
I know.
I really should have brought my stripes today.
Yeah, that's one of those.
But Brown Act does trump Robert's rules.
Oh, absolutely. Absolutely. Yeah, even if the board adopted a rule that says we're going to follow the parliamentary procedure and Robert's rules to the death, it doesn't really mean anything because the Brown Act still controls you as a public body in California.
Hey, Ruben, before you move on to the next slide, can you elaborate a little bit about these bullets, like significant exposure to litigation?
Absolutely.
I mean, the other ones are like existing litigation is pretty clear cut.
I'm gonna go to my notes here a little bit because the statute is actually pretty robust and there are specific rules of the different types of permissible closed sessions for litigation. Some agencies actually are finding themselves under the gun recently about their practice of how they're going into closed session on litigation, because it's very easy to fail or forget to comply with these little nitpicky requirements I'm going to tell you about right now. Okay, so as you said, existing litigation is easy. It's an ongoing case. We know who's suing us. We know what for, and we're going to talk about it to get advice from our lawyer in closed session. Exposure to litigation is a little bit trickier. So circumstances that lead to you or your counsel making a determination that you're exposed to litigation are as varied as somebody standing up at the podium and saying, you dirty so-and-sos, you broke the law, or you whatever it is. Your truck ran over my cat and I'm going to sue you. So that's an open threat of litigation in a public meeting. That is a significant exposure to litigation, and the Brown Act says, we're going to let you talk about that in closed session. So what you would do is you would make an announcement. I'm sorry? Oh, yeah. The Brown Act says that before you go into that closed session, you would say, Ruben Duran stood up at the podium and said he's going to sue us, so now we're going to talk about our potential exposure to litigation because of that announcement. Another circumstance is you might get a letter from a lawyer saying, I'm going to sue you. My client's going to sue you on the formulation of the fees for his new development, and these are the reasons why we think you're wrong. Well, the body's now on notice. The agency's now on notice that this guy or woman's got a lawyer, and we face some potential exposure. So the same thing, you would make the announcement. Sometimes there are things that have happened that the public doesn't know about or the potential plaintiff doesn't know about. And the Brown Act says that you're allowed to go into the closed session without revealing any of those details because you don't want to harm your position in the potential litigation. And I'm trying to think of what would be a good example, but it's too dangerous to do that, quite frankly, because I don't know what you guys got going on.
So does that mean that there would have to be a recognition of conduct that would constitute a
Some potential liability.
significant exposure? And
Yep.
what exactly are we talking about significant? I mean, how is it construed? Is it pretty narrow or broad? I mean, because
So it's-
who gets to make that determination? Is it the presiding body or the chair or their attorney?
It's the body upon the advice of counsel. So the Brown Act allows you to convene into closed session to discuss whether you actually face significant exposure to litigation so that it's permissible to have the closed session. So what would happen is your staff or your counsel would say, board members, I need to talk to you about something where we face potential liability. I can't discuss it in the public. I would ask the board to meet in closed session so that I could lay out the facts so that you can make the determination whether we face significant exposure so that we can properly agendize it for the next meeting.
So that would be, you mentioned the latter part of your statement, it was upon council, so so we can't just on our own as a presiding body say, look, there's significant exposure. It has to be based on opinion.
Well, and I mean, it depends on where the information came from. I mean, if you're the only person that has that information and the board needs to know it, sure, it could come from you. I'm assuming that you would have spoken to your staff or your council about it beforehand so that you can develop the facts and bring it to the board. So yeah, I apologize for assuming that the lawyer's always going to know. Maybe the lawyer doesn't know sometimes, but the lawyer should. The lawyer should, because those are legal liability issues.
And this could be your example that you were looking for. You write something with such precision that you alert the other side to causes of action that he may or may not have been aware of. You're not required to do that.
Sure.
And in fact, you would be, well, you shouldn't do that.
Right.
You can't recite facts that are not known that could lead the litigation in a particular direction and things like that. So
Right.
that's why
Right.
why it's general, but
But if there are facts that are known, then
Yes.
you have to recite those facts.
right, right, and yet I think that I mean I'm wondering as we're having this discussion whether you don't have to at a threshold when you go in, if this is an issue, make a determination before you have a discussion that there's potential serious litigation that will allow you to have the subsequent discussion.
That's right. And the Brown Act specifically says that you can convene into closed session to make that determination.
Okay.
I mean, are there reasonable standards that are applied for closed sessions?
On litigation?
Yeah, like on significant exposure. This is the part that I always, as I've seen some agencies use it liberally, some agencies are a little conservative about it. Is there some sort of reasonable standard or guideline that the Brown Act provides and says, look, this is your confines of dealing with what significant exposure entails?
So the Brown Act attempts to do it by giving us 6 specific situations or six types of situations that could justify the determination about a significant exposure. And I believe I have slides about that. Hold on.
Is that like the real property and agency, all that good stuff? Yeah.
I'm sorry, I didn't hear what you said about property.
Was that one of those categories that you can talk about real property or an evaluation of a CEO?
Sure, but
Those are-
no, this is different though. 'Cause
Okay.
You were asking about litigation, right? You were asking about
So they do provide clarity.
exposure to potential liability, exposure to litigation. So these are the six scenarios. We talked about one already, Trustee Otto. Facts not known to the potential plaintiffs, and that's where we can go back to talk about them and decide whether we should add it to the closed session agenda. Facts known to the potential plaintiffs, essentially, something has happened and we think that the district could be at risk. There's potential liability. We'll state those facts. The receipt of a claim or another writing threatening litigation, the example I gave earlier about the developer and the fees. A person making a statement that they're going to sue you in an open session. Now, the reasonableness factor comes down to this. So, all due respect to the guy with the teddy bear, let's just say when he was at the podium, he says, "I'm going to sue you for violating my rights to nap wherever I want, whenever I want." So he's threatening you with litigation, right? And quite frankly, the lawyers in the room know that anybody can sue anybody over anything at any time. You file a paper in court and you pay your filing fee, and that's a case. Well, we have to exercise some discretion here, some sense of what's reasonable and what's not. So for the gentleman to sit up there with his teddy bear and threaten to sue us for not giving him his nap, we're not going to call a closed session over that item, right? Probably. We'll wait till we get the lawsuit.
And then does it, let's take a hypothetical, you get the threat outside of your board meeting.
Mhm.
Is that, how does that work? Like, let's say, the presiding body or like the chair, does that person have authority outside of the board meeting or a duty to comply or report or act on that potential threat because, it wasn't brought up in the meeting and it was only brought up to one person or another?
So I'm not sure that I'm following you, Trustees Zia. Are you talking about whether that person can ask that the item be agendized for closed session?
No, let's say we're in a community meeting or in a conference, we get a threat.
Uh-huh.
I'm going to sue you guys. It's not necessarily in the confines of the board meetings. Is that something that is even something that
Should
the
you take
agency
action on it,
yeah,
is what
the
you're
agency
asking?
should apply a reasonable test and say,
Right.
well, look, this is just outside of the confines. It's not really the presiding body. It doesn't really have authority outside of here.
Right.
Or if it's the president or the chair of the board, or is there something else? Is there anything else that that person or body needs to be mindful of outside of the board meeting?
A couple things. So if the threat just happens, just someone sort of mouthing off to you and says, I'm going to sue you, bastards, excuse my language, I apologize. I'm going to sue you, but there's nothing to back it up, but there's no letter from a lawyer, there's no claim that's been filed, then you don't necessarily have to do anything about that, because who knows whether the threat is credible, right? If it happens in a public meeting, it's different. It would give you a justification. But it's a case-by-case basis. How credible is that threat? So. Okay, and then here are the other items that can be discussed in closed session. Real estate negotiations. The real estate negotiations exceptions sometimes can be tricky, and there are some public agencies in the past that have been accused of sort of abusing that exception. Really what the law says is you can meet with your designated negotiator, whom you have to name on the agenda or before you before you convene in a closed session. But you're allowed to talk about the price in terms of payment for that real property, whether you're buying or selling. You're not necessarily allowed to talk about what development might happen at that property or other things relating to the property, unless they relate to your price in terms of payment. So I always tell my staff, look, either you've got an appraisal or you're ready to talk an appraisal, or you're ready to talk about things that are going to affect the price in terms of what that real property transaction might ultimately be.
This is a sort of a hybrid remark or question, but I've been frustrated in trying to do real estate things in closed sections because of how limited what it is that you're allowed to talk about. And some of it's Brown Act stuff, but others of it is just the way you sell property and the rules for the selling property. I feel like you can't make good decisions limited to the narrow things that you're allowed to talk about, but I think that's a question for the legislature, not the.
I think that's exactly right. I mean, I couldn't put it any better, and I've shared your frustration at times. 54957.6 is the closed session exemption for public employment and labor negotiations. So whether you're talking about hiring or firing or disciplining or demoting employees, those are allowed in closed session for the purpose of protecting the employee's confidentiality, right? Our personnel facts are personal to us and deserve a certain amount of confidentiality. Labor negotiations